Most Americans don't have an estate plan, even though the vast majority recognize the importance of having one. In this video, we'll touch on all the main tenets of an estate plan, why it's so important to have one, how to avoid common mistakes, and ultimately, solutions on how to get started. This video will be for you whether you have an existing estate plan or not. Maybe you just want to make sure that you have all the pieces in place. Maybe you haven't updated your plan in 10 years. Maybe you're 30, maybe you're 70. It's never too early or too late to make sure you have a strong and reliable plan. I find that a lot of people, when thinking about their estate plan, feel overwhelmed, but let's break it down into 5 main areas that you should be paying attention to: your will, your trust, your powers of attorney, healthcare directive, and beneficiaries. Let's dive into each one individually. Starting out with the basic last will and testament. This is a single document that lists all of your wishes for when you die. Pretty simple. Who inherits which of your assets? Who will be your executor? That's the person you trust to carry out the will's instructions. Typically somebody you find to be competent, reliable, could be a spouse, a family member, or an attorney or other professional as well. You can name guardians for minor children, say who will take after your pets, state funeral wishes. Wills are simple to create, they're not too costly, and they work for simple estate planning situations. Maybe you don't have a ton of assets, they're all located in one state, and you have a pretty straightforward idea of how you want your assets to pass. Trust. So every time I mention a trust in this presentation, you can assume I'm talking about a revocable living trust. Unless I say otherwise, this is the most common type of trust that works in most cases. Revocable means that you can change the conditions of your trust at any time, which is good because people's situations change and you're not locked into any arrangement. A trust is a legal arrangement where your assets are held and managed by a third party according to a set of rules that you create. So what does this mean? It's kind of like a folder where you choose which assets go into that folder. It could be your house, bank and investment accounts, business interests. You transfer those assets to the trust, and then you decide how you'd like those assets to be managed. So we'll talk about all the benefits of having a trust in a minute and why you might want a trust instead of just a will. But first, we'll go over some of the basics of the parties to a trust. So there's the grantor. This person creates and funds the trust. It's normally yourself. The trustee manages the trust according to the rules. This is likely also yourself while you're alive. And then when you pass, your successor trustee, who you name, will take over. And then the beneficiaries. These are who receives benefits from the trust. So let's compare and contrast some features of trust versus wills. Probate is one of the main differences of trusts and wills. Wills go through probate, trusts do not. Probate is the process by which the court validates the will. So when you die, the will goes through the court system, which can be slow and costly, estimated around 3 to 7% of the total estate before attorney fees and court fees, plus a minimum of 6 to 8 months of waiting in most states. It's a public process, so all documentation and the will itself are available to the public for anyone to view. So if you value privacy, you might prefer a trust. Because wills are public, they can be disputed. So if someone's upset with the will, they can contest that for improper execution, fraud, undue influence, and this can slow down the process and potentially revert your wishes. If this process sounds like something you would rather avoid, a trust does bypass probate entirely. Wills distribute their assets to beneficiaries one time after probate is complete. A trust has much greater flexibility over timing and distributions. For example, with a trust, you could say, my grandson will receive my wedding ring when he turns 25. It suits all kinds of more complex situations. For example, my sister will receive the income from my rental property, but if the property is sold, it will go to my brother. You can also give income from dividends in your accounts through your trust. This can be done after you die or while you're alive, as it is a living trust. You can make your legacy last, ensuring your beneficiaries don't burn through the money. For example, you could say distribute X amount to each grandchild upon their birth, so you can even give to people who aren't born yet. Or hold this money in the trust until my grandchild turns 18. If you have minor children or grandchildren as your beneficiaries, definitely consider a trust for this reason. You can withhold assets until they are adults. And if you have a child who you're worried is financially irresponsible and might burn through the money, you can give your successor trustee discretion over how the money is distributed. So trusts offer a lot more options when it comes to distributing assets than wills, and you can be very precise. Generally, if you have a large estate or it's more complex, you'll likely want a trust. This could be because probate fees are higher for large estates. If you have assets across multiple states, it may benefit you to not have to go through multiple state probate processes and to have a trust. If your situation is simple, you know who you want to inherit what, you're okay with it being all at once, maybe a will is right for you. Feel free to reach out and contact me and we can discuss what might be right for you. You can find my email in the description. So if you have a trust, does that mean that you should not have a will? You actually very much should still have one. Why? Well, a will is capable of addressing the pieces that you didn't put into the trust. Things that you forgot about, leftover assets. If you have a trust, you should have what's called a pour-over will. You can basically say, any property not already in my trust at death will be transferred to my trust, and then it will be distributed as a residual asset and avoid probate. So it's kind of like a funnel catching leaks from a faucet and then redirecting them back into the bucket that is your trust. A will can also do a couple things a trust can't, like appoint guardians for minor children or pets, and also specify funeral wishes. So don't think of trusts as substitutes for wills. With a trust, a pour-over will would still be necessary to have a complete estate plan. So beneficiary designations, this is really crucial. A lot of people don't understand how this works, and it can create a lot of problems. If you have beneficiaries listed on your 401k, your IRA, life insurance, bank account, it does not matter what you said in your will or your trust. Account level beneficiaries take priority. Someone might say, well, my trust is dictating that my beneficiary is Albert. Well, if your IRA itself has Sarah as the beneficiary, it does not matter what your trust says. That money is going to Sarah. So people need to double check all of their beneficiaries and make sure they know where they're going and make sure they understand what takes priority here. A lot of people have old 401ks from jobs that they haven't touched in years, that they may have put their parents on, and now they are married and they have children who they would probably prefer to be the beneficiaries. When you work with us, we make sure to check all of these accounts because this is a really crucial step. What happens if you're in an accident and that puts you in a coma or damages your cognitive abilities? Or if you get dementia or some other illness that means you can't think clearly or make decisions for yourself. You want to make sure that you have somebody in your life who you can designate healthcare decisions to when you can't make them yourself. So there are two crucial pieces here that you have to have established, and they go under the umbrella of a healthcare directive. A living will let you express your medical treatment wishes directly in a document. They will not be overridden when you're incapacitated. So if you have a preference for treatment, resuscitation, organ donation, ventilators, anything of that sort, it's important to have that in your living will. So you won't be in a situation where your children or your friends have to debate these decisions for you. In addition, a durable healthcare power of attorney is someone who you appoint to make healthcare related decisions for you if you become incapacitated. A living will probably wouldn't cover all the potential scenarios that could come up, just the ones that you stated in it. So this allows somebody to make all other medical decisions on your behalf who you trust. A financial power of attorney operates similarly, but for financial decisions. Let's say you were in an accident and you needed funds for emergency treatment. If you didn't have a financial power of attorney, your spouse, your children, your parents, nobody is allowed to withdraw money from any of your accounts. And that's where having a financial power of attorney is really crucial. A durable financial power of attorney. They can make decisions for you like paying bills and insurance, managing cash flow, transferring funds, withdrawing cash, managing investments, filing taxes, and even managing your business if you own a business. So, estate tax. Estates are not taxed at the federal level for most people. But if the value of your estate exceeds $15 million or $30 million married, the portion above that threshold is taxed at 40%. So for example, if you are single and your estate is valued at $16 million, $1 million will be taxed at 40%. Obviously, this doesn't apply to most people. Many states have estate and or inheritance taxes. It really depends on the state. They have their own individual rules. So we'd have to look at your state specifically and see if you would hit that threshold where you start to get taxed. But if you have a state that's large enough to be taxed at the state or federal level, this opens up a whole other conversation about estate planning in terms of gifting and, shielding assets from taxations, and might even involve an irrevocable trust. But we're not going to get to that in this video, but that is something that we do have experience planning for our clients. So if that is you, you can let me know. So now you understand the key pieces of estate planning, which is a great first step, but now it's time to put a plan into place. So there are a lot of ways to put together an estate plan. You can put together a will or trust for yourself through an online will platform. This is a cheap option, it's self-guided, and that's also the biggest problem with these solutions. You don't have a professional there to double check everything, point out holes, or state-specific quirks that you can benefit from or that you may want to avoid. No one is there to check your beneficiaries or give you professional suggestions for your situation. You could do it through an attorney, which is the most expensive option, but you'd have a very secure will or trust. The problem is that estate plans aren't one and done, and they require updates over time, checking in every few years, adapting to address changes and regulations. This is where attorneys can get pretty expensive, as they likely charge for updates, and unfortunately that can disincentivize people from updating their documents as needed. So I'm going to introduce a third option, and this is what we do for our clients. Our firm is partnered with Wealth.com, a leading digital estate planning platform available exclusively through licensed advisors. This provides our clients with an affordable solution where you're likely paying less than you would an attorney, but you also have professional guidance through each step. When you sign up for a will or a trust, you'll also be set up with a healthcare directive, financial power of attorney, all included because we don't believe in charging you a bunch of extra fees just to have a complete plan. After you create your document online, you'll be able to get a summary of your plan and see how it holds up. If you have existing estate planning documents, you can upload them to Wealth.com and it'll analyze your current plan, create a summary for you, and outline where the weaknesses might be so we can spot areas for improvement. Often people don't know the details of their existing plans as well as they think, or where their money is really going. So this platform can simplify what is a very complex document and also point out changes and regulations that might have happened since the last time you updated. And once your estate plan's created, you'll have secure virtual access to those documents, and they all live in one place so you won't lose them. You can update your plan whenever you want without extra charge. Our firm will be there to consult you throughout the life of your plan should you have any questions. And we'll also run a check on your beneficiaries, on your life insurance, retirement accounts, investment accounts, just to make sure that your money is going where you intend and that there are no holes or inconsistencies. So here's how the process works really quick. We would schedule a meeting to get to know you and your situation and make sure that what you need is suitable for what Wealth.com can offer. If it's a good fit, we'll send you a secure invitation to get started. We can help guide you through the information gathering process and create your plan. Then you'll have a draft of your plan for us to finalize and review before you pay. So you only pay once those documents are in their final form and you can see for yourself what they look like. So I hope that you all found this helpful. Again, if you want to get started on estate planning, we would be happy to help, get to know your situation, and put you on track to make decisions that work for you.